right, welcome everybody. We're going to get started. It's a little bit after 6. Thank you all for coming. All right, so my name is Emily Rogan and I'm the program coordinator for United Policyholders. You guys have probably heard this many times, but about United Policyholders, we are a nonprofit organization and we are a voice and an information resource for insurance consumers. So we're here to educate you on different aspects of the insurance recovery process. We are funded by donations and grants. So grants, our work here is funded by the Home Depot Foundation, and we get donations from individuals and businesses as well. So we don't take any money from insurance companies and we don't sell insurance. We have an insurance-y name, but we are completely independent from the insurance industry. Our work gets done thanks to many volunteers. We have 2 volunteers here today to help teach this workshop. And you can find more information about our organization and much, much more information at our website, uphelp.org. You'll hear that website many times tonight. So we've been around for, this is our 25th year, helping with many different disasters. They're all listed up here. We started after the Oakland-Berkeley firestorm. We were involved in Hurricane Katrina, the 2003 Cedar Fire, which is Karen's fire, and she's a volunteer who's paying it forward all the way through this fire as well. So we'd like to thank the Home Depot Foundation for very generously supporting our organization to be able to bring this program to you, and to our volunteer Tina Clark, who helps us secure the space, and to Kimberly, who's helping us film this. So this is wonderful. So this will be posted on our website. So if you don't remember everything, you can log in and re-listen to it for a refresher.
Thank you.
So the fine print. The information presented in this program is general education only. We don't give legal advice. Our speakers today are volunteering their time, and we don't warrant or endorse any of the speakers, though we think they're pretty great. So our free recovery resources. Hopefully you've all gotten copies of the little yellow book right now. If not, there are copies available on the table, and if you have a neighbor or friend who you think would benefit from this information, you can grab one for them as well. We also have little cards called the Claim Help Inventory cards. I don't think we've settled on a name for them, but you can get all the information we have for your contents portion at uphelp.org/download. So we have cards on the table for that, and then claim diaries as well. Our Ask an Expert form is available on our website at that address, and you can ask confidentially your questions. And what we will do is we will assign them to professional volunteers who volunteer their expertise for our organization to answer them. They won't see your contact information, and you'll get an answer to your question. I would suggest that you write Valley Fire Survivor or indicate your fire in your question so that it can be bumped to the top, because we will address those first. And then again, our website is available 24/7, so if you have a question in the middle of the night or you can't sleep, something's bugging you, there's a wealth of information, and we have everything from sample letters to recovery blogs to publications on all different aspects of the claim process. And if you're looking for something that you can't find, you can always send me an email. And my email is emily.rogan or just emily@uphelp.org. So we also have a disaster survivor support network that you can access. All you have to do is send me an email, and we have about 160 previous catastrophic loss survivors who are mentors in a sense, where they can just give you some real life insight and emotional support if you need that. Just all you have to do is send us an email. And it's a standing invitation, so you don't have to do it immediately. At any point, if you feel like you would like some emotional support, you can be hooked up with another survivor. Okay, so we are in the middle of our 6-month survey right now. We just released it. The 6-month anniversary is right around the corner, and so please, on those purple half sheets is this information as well. So we really urge you to take our 6-month survey. We're going to be looking for common problems and trends, how things are going with your insurance, which insurance companies are treating people fairly, which ones do we see negative trends with. This data is really important. You can stay anonymous if you prefer. All of the stats will be gathered and the only information we're going to be releasing is data. So, 55% of blank and blank. So none of your information will be identified unless we specifically contact you, and you will give your positive affirmation if there's something that we'd like to share. So please take the survey, uphelp.org/V as in Valley survey, and if you do put in your email address at the end, it will be entered in so you can receive a $50 Amazon gift card. There'll be a raffle. I think we're raffling off 2 cards, so chances are pretty good. And thank you in advance if you've already filled out the survey. We really appreciate it. We know their numbers are slowly trickling in. The other thing that we wanted to make an announcement about is if you have any friends, or if you have been dropped by your insurance company since the fire, there are legal protections to make sure that that doesn't happen. So hopefully that's not the case. If it is, you should contact the Department of Insurance immediately. But if you have a friend who maybe didn't lose their home and you hear that they've been dropped by their insurance company, urge them to reach out to us, because we're working with a couple legislators to make sure that that doesn't happen. And it's really good for us to hear that information and make sure that we can get our fingers on the pulse of what's really happening in terms of people being able to keep their insurance right now. Okay, so that's all for the welcome and announcements. I'd like to turn it over to Karen Remus, and thank you so much.
Thanks.
Oh, you're so sweet. All right, you guys, so tonight, as you know, we're talking about dispute resolution mechanisms. We're going to be covering 4 of them. I'm going to start off with negotiation. Again, I'm Karen Remus. I am a 2003 Cedar Fire survivor from San Diego. So again, there's my husband and I on the debris of our home. I think probably most of you have a picture very similar to this in your photo album, unfortunately. And again, I'm extremely sorry for your loss as somebody who's been there firsthand. I hope tonight's presentation is useful. Talking about negotiation, the very first option that you really want to be looking at when you're trying to resolve any sort of dispute with your insurance company is negotiation. You can work to resolve that dispute by negotiating on your own or hire a professional. Those are kind of the 2 paths that are generally followed here. So tips for negotiating on your own. Let's take that first path. Say you're like, hey, I'm going to try to resolve this on my own. I really don't want to go down the professional path now. What are some tips? What are some strategies for doing this effectively? The very first thing is to create a strong paper trail. What does that mean? Well, first of all, keep a claim diary. We have those little purple organizers that we've handed out. And what this means is that really any sort of conversations, representations, promises by insurance company personnel, it's a really good idea to jot that down. What was the substance of what was said? Who said it? What was the promise made, if any, and the date. If it's something, again, like a promise, some sort of important representation, we urge that you confirm that in writing by following up with a short email or a letter. So step 1, keep a claim diary of communications. It'll help you keep track of the claim so you can keep it moving forward. Again, it's not unusual to have multiple rotating adjusters in these large-scale disasters. So keeping track of who said what when will help you strengthen your negotiating stance as you move through the claim. And then again, if it's something like a promise or some important representation, oh, there's no deadline for you completing your personal property inventory. We'll take it at any time. You know what I'm saying? That's an important promise that they're making to you. That's an important representation that they're saying to you right there. Confirm things like that in writing. Email is fine, letter is fine as well. So create a strong paper trail. Other strategies. Really improve your negotiating stance by effectively communicating with your insurance company. What does this mean in brass tack terms? Use good grammar, proper capitalization. It's a business transaction. So again, you want to appear and communicate as a very thoughtful, savvy, almost like a business, like I said, think of it like a business transaction is the best way to really kind of think in terms of your communication. I think the hard thing is even though you may know it's a business transaction, since it was your home, it doesn't feel like a business transaction. It feels extremely personal. So again, but trying to keep that business-like demeanor is really important. Very important, don't use your insurance company as an emotional outlet. I can tell you from firsthand experience, I know how tempting that can be when maybe things have reached an impasse. That would be a really nice way of putting that. But again, you're always the good guy in the communication. You want to avoid writing or saying anything that makes you look uncooperative or the source of problems or delays. We once had a guest speaker who said, imagine any communication that you have being flashed up, I got on a screen like this in front of a jury. And he goes, my point is not that any of you are going to trial. He goes, but think of it that way. How would it look if that communication was flashed up in front of a room of people? Would that room of people think you were the good guy, that you were the person behaving reasonably? That's how you want to think of it. So even though the process can be frustrating, again, you really want to make sure you don't use the insurance company as an emotional outlet. Letters should be to the point, professional, polite. Again, always reminding how cooperative you have been and continue to be. The best tone that we would suggest you use, polite assertiveness. All right, so again, polite, businesslike, not a pushover, but again, maintaining that polite, businesslike demeanor and tone. Credible and detailed documentation on any disputed issue will absolutely improve your ability to negotiate a resolution. So let's take a couple of examples. Say you're having a claims handling problem. Having documented that problem by laying a good paper trail, just like we talked about 2 slides ago, will help resolve that, because you will be able to lay out the history of that problem in a very clear, concise fashion for the adjuster and or their superior, their boss, if you have to elevate that problem, all right? So again, that would be the documentation on a claims handling issue. What about a dwelling dispute? Dispute over the cost of the dwelling, repair or replacement. Credible estimates from licensed contractors would be a good example of having good, credible documentation to help you resolve that particular type of dispute. How about a contents dispute? Well, again, the more detailed, credible documentation you can provide, again, the specifics on the item, documenting the cost of replacement by providing them information that you've researched online or otherwise. So again, credible documentation improves your negotiating stance. And so these are a couple of ways that would come into play. When engaging in a back and forth negotiation with your insurance company on a disputed issue, always make sure that you ask for a written response within a specified time frame. All right, so ask, and again, using that politely assertive tone, thank you very much for responding in writing within, and then put a commercially reasonable time. 7 days of the date of this letter, 10 days of the date of this letter. So again, politely assertive, asking for a written response, but within a specified time frame, because that way, if they don't respond, then you can follow up again. Now who's looking reasonable and who's looking unreasonable? All right? If you leave it open-ended, who knows when that response will come? So again, you want to be able to keep any sort of negotiation that you're having on a disputed issue moving forward. And by requesting a time frame for response, it'll permit you to do that. All right? Go up the chain until the disputed issue is resolved. If you're unable to resolve an issue with your adjuster, go up the chain within the insurance company, all right? The contact order is upward, starting at the adjuster and going on up. Chances of resolution increase the higher you go up, because the higher you go up, the more annoyed that upper person is going to be that they're being bothered with this problem. Why hasn't this been resolved? So again, it's all in how you do it. Say you get a no on a particular issue from your adjuster, and you feel like you've got good grounds to make your point on that disputed item. Well, thank you. I really appreciate your response and the time spent, communicating this to me. However, I need to take this to the next level. Can you please provide the name and contact information for your supervisor? Thank you again for your, communication. Again, do you hear it? It's politely assertive. It's not like, what? and give them a piece of your mind, that would not be the way to go. Again, you're cooperative, you're reasonable, but you are now moving up the chain in a politely assertive fashion, all right? Again, don't sign anything like a waiver or release without getting advice from an experienced policyholder attorney. Your policy does not require you to sign away any legal rights in order for you to get fairly paid for a covered loss. So again, be thoughtful about forms labeled anything like waiver or release. And our advice on that would be to, again, check in with an experienced policyholder attorney before executing any document of that type. All right, so those were strategies, ways to work on effectively negotiating on your own. What about hiring a professional? All right, your choices typically in that arena are two: public adjuster and an attorney. And which one you choose often depends on where you are in the process. As a general proposition, again, I'm not saying that it always holds true, but I would say generally speaking, typically PAs are more involved early on, where you see attorneys coming in a little bit later in the claims process when there's a dispute. Not always, but I'm going to say if I was going to make a generalization, that's where I would go with it. Let's start with public adjusters. A public adjuster, commonly referred to as a PA, is a private claims adjuster that works for you, not for the insurance company. Don't be rushed or pressured into hiring a PA, all right? So again, take the time to do your due diligence. They typically work on a commission anywhere between 5 to 15%, a contingency, which means they're taking a percentage of the recovery that you get. So they're working on that percentage. They'll get, so depending on their contract, between 5 to 15% of the amount you recover. Pros and cons, as with all things, there's a cost benefit to every decision made in life. What are some of the pros? Well, a diligent PA can take the weight off your shoulders by documenting the claim and negotiating with the insurance company on your behalf. All right, so a good one can help. Cons, an overloaded or unethical PA can make things worse by slowing things down, diminishing your settlement. And again, too, another con is that they do, of course, take a percentage of your settlement, so it costs. So again, pros and cons. If you decide to hire a PA, then only hire a licensed public adjuster. They are licensed by the Department of Insurance in the state of California. Ask for their license number and check it. You can check that on the Department of Insurance website. Ask for references and check a minimum of 3. You guys are swamped, but undoubtedly you've had friends or family say, like, how can I help? What can I do? If you're thinking about hiring a PA, ask one of those people who've offered to help you. This is a task that can be, handoff. Hey, can you call on some of these people and check them out? I've got these references, give me a hand with that. So again, look to hand off where you can. Do you know what I'm saying? Stuff that doesn't take your immediate attention. We'd also suggest that you would ask if that public adjuster is a member of, I would say, NAPIA, and I would also add to that list CAPIA, so National Association of Public Insurance Adjusters, and its state affiliate, or state, corollary, California Association of Public Insurance Adjusters. Those are their national and state trade associations. So again, certainly not, for sure that person's going to be great, but I think it's a good data point, and that's what you're looking for, data points to try to help you make a decision. So make sure you agree up front with the PA, whether that person will get a percentage of money that you've already agreed to with the insurance company or not. All right, so important to be clear on that. All right, what other professional can we look to? Attorneys, all right? So again, public adjusters and attorneys are typically the two kind of, professions that can offer, again, professional help to help you negotiate should you be facing a dispute. If you feel like you've hit a wall in negotiations on your own, hiring a good plaintiff policyholder attorney may be the right choice. The first thing, find the right attorney. What you want to look for, you just heard me say, and I'm going to repeat it now, plaintiff policyholder attorney. This is a niche area in law. You know how basically you'll go to the orthodontist to get braces instead of your general dentist? It's the same thing. You know what I'm saying? You don't want the general business attorney, you know, you want a plaintiff policyholder attorney who is extremely experienced in this area of law and the dynamics with the insurance companies, all right? Ask friends, family for a referral. You guys have a great network within your community here. So again, check with your network here. Friends, does anybody know somebody who can recommend a plaintiff policyholder attorney? Other ways to find them. Refer to the Find Help section of the United Policyholders website. Again, another great data point for you as you're trying to, again, you know, if you're trying to hire an attorney, do your due diligence. Again, just with the public adjuster, ask that plaintiff policyholder attorney for references and check them. Check a minimum of 3. Other ways of utilizing an attorney's expertise. Some previous wildfire survivors have hired an attorney to ghostwrite letters, correspondence back and forth with their insurance company as they were negotiating. That way, again, they felt, I can think of one in particular from another disaster who did this with great success. He felt like he didn't want, what he told me, he's like, I don't want to put them on the defensive, but this guy has got the expertise to really be able to negotiate in a really more effective way. So he hired that attorney to ghostwrite with great success. So you'll find that people will use an attorney's services in different ways. So again, there's not just one way. It's not just to hire them to sue. There's other ways, creative ways that you can use an attorney's services to help you negotiate effectively. So again, definitely seen previous wildfire survivors use an attorney's expertise in that fashion. All right, so we've talked a lot about negotiation, so I'm going to switch gears here and I'm going to talk about mediation for a few minutes. Now I'm going to be talking about mediation generally and what mediation is, pros, cons. I think our guest speaker is going to be talking about the DOI mediation program during his slides. The Department of Insurance has its own mediation program, and I thank our speaker for including those information about that program in his slides. So I'm just talking about mediation generally to start off. What is mediation? Well, it's an informal, non-binding process for conducting settlement negotiations between you and your insurance company. All right, so it's informal and it is not binding. Generally speaking, insurance company personnel are trained in, again, the process of mediation, litigation strategies, negotiation. They do this every day. They're extremely experienced in mediation, litigation strategies, and negotiation. While policyholders, again, most of us are, a teacher, work at the bank. This is not what we do every day. So again, the insurance company personnel typically very experienced in these processes while policyholders are not. So it's really important that you find a mediator that is fair and can level the playing field with the insurance company. So you want to find a mediator that has experience in resolving insurance disputes. So again, that's one of the very first things you should look for if you want to utilize this process, a mediator with experience in resolving insurance disputes. And also only agree to a mediator that has no financial stake in the outcome of that mediation, all right? So key things. Mediation techniques. Candidly, mediators can use a variety of techniques to bring people to the table and to try to reach resolution. A very common approach that's utilized is that the mediator will have the parties in a common room to start off, will speak with them openly together, and then we'll isolate each side and we'll shuttle back and forth. Talk to one side. What do they have to say? What's their position? What monetary value are they looking for? What monetary resolution? Then they'll go to the other, party in another room. The goal in doing this is they're trying to avoid conflict, that face-to-face, like, what? No, like, do you know what I'm saying? So he talks to them, then goes to the other room, he or she, and goes back and forth. So again, trying to maximize constructive dialogue while minimizing, confrontation. Who pays the mediator's fees? It can go a number of different ways in mediation. The fee can be split equally between you and your insurer. The insurer might pay the entire fee. It could be that the insurer advances the fee and then you agree to reimburse them for your half out of the settlement. Again, try to get them to absorb the fee if you don't settle as an incentive for them to come to the table. Look at your policy. There might be, again, a payment provision covering claim adjustment expenses that you could argue should be used to cover your portion of the mediation expenses. You may or may not be able to successfully argue that, but it's worth asking and exploring. All right. Preparation is crucial to a successful mediation. The better you prepare for mediation, the far greater your chances of resolving your dispute at a mediation. It really comes down to preparation, all right? Pros. What are some of the pros of the mediation process? Well, it's inexpensive as compared to something like a litigation, right? It's much less expensive. If you don't like the result, you can walk away. You're not bound to it. That's a plus. It can be a very efficient way of putting a dispute behind you and moving forward. Also, it educates both sides about the strengths and weaknesses of each other's positions. You know, maybe you thought you had a strong position, but they provide information, you're like, or vice versa. Maybe they thought they understood what was going on, but because you've come to the table and explained and provide your credible documentation, they're like, oh, there's more going on here than I thought. So again, you educate both sides. What are some of the cons of mediation? Well, an insurance company might not really be seriously interested in settling, but is really using the mediation to gather evidence and to test the strength of the case, almost as though it's a pre-litigation discovery tool. So that can be a con. A mediator may inappropriately try to scare or discourage a party and discourage a policy holder in an effort to force a settlement. That could be a con. Mediator could potentially tell an insurance company things that you asked them not to tell them when you were talking to them privately. So again, that's a risk. An insurance company might take advantage of your lack of experience to your detriment. You know, again, they use these processes all the time. You know, again, maybe it's your first and only time you've ever even been to a mediation. So again, you know, it can be unlevel. You may leave the mediation feeling that it was a waste of time and money. Those are some of the cons. Before going to mediation, if you go to mediation, insist that the insurance company rep who attends the mediation have sufficient dollar authority amount to settle. So again, you don't want to go spend your time, your energy going to a mediation, and then their rep doesn't even have sufficient authorization to settle the amount of your claim. Like, what was the purpose of that? So make sure that that person, and clarify that in advance, that their rep will have sufficient authority to settle for the dollar amount that you want. Consult with or bring an attorney. I would say especially if the insurance company is bringing one. It's worth the investment of time to at least consult to try to help them parlay and your strongest arguments to try to help you figure those out and how to best document those and take a look at what you've got. But especially if they're bringing one, it's a good investment to bring one. Per the previous slide, prepare, prepare, prepare. That's how you're going to get your best result. Generally a good idea to give the mediator a written summary of your position before attending the mediation. And it's really advisable to seek an attorney's help in preparing that position paper and that summary. Keep your expectations low and be ready to walk away, again, if you're not happy with the settlement that they're proposing. Again, remember, many disputes settle after mediation, but it's the groundwork that you laid in mediation that leads to that settlement. So you might feel dissatisfied in the moment, like, oh gosh, took the day off from work and got all this ready, and like, we didn't even settle. You settle a week later. So keep in mind, it can be a precursor to a later settlement, all right? All right, so it's my pleasure now to introduce our next speaker. Don Lesser is a plaintiff policyholder attorney, as I spoke about a little bit earlier. He has driven up here today. We really thank him for his time. He's going to be talking to you again about appraisal, the DOI, Department of Insurance specific mediation program, and the litigation option. Thank you so much for making the time to come up to me.
Thanks.
And you can see.
Right.
Mm-hmm. And you can see.
Oh, awesome. Okay, thanks. Hi, my name again is Don Lesser, and I have a small law firm in San Rafael in San Francisco, and one of our major practice areas is representing both individuals and companies, businesses, in recovering policy proceeds that they're entitled to. And it's honestly one of the most satisfying parts of my work, because I really feel like I am doing the right thing for people who are deserving. So I want to take a few minutes tonight to cover, as Karen said, basically three things. There are really three ways to resolve your insurance claim. There is, as Karen talked about, negotiation or mediation, and mediation is just really a formalized process for negotiating a resolution to your claim. You're getting the assistance of a neutral third party. There's also in your insurance policy a provision that calls for certain types of disputes to be subject to what's called an appraisal. And it's a bit of a misnomer, because most of us, when we think about appraisal, think about having our house appraised, or some piece of property, or our car, in terms of what its value is. And in a real sense, that is what appraisal is about, because an appraisal in the insurance context is about determining what the amount of your loss is. So, for example, if your house has been burned down or has been substantially damaged, determining the value of that loss is figuring out what it will cost to either what it will cost you to replace it, or if it's a total loss, figuring out what the actual cash value was at the time. If it's your personal property, if the contents of your home, then appraisal is about figuring out, again, what the cost of replacing those items are, or their actual cash value. That, as most of you I think know by now, that's only one piece of resolving an insurance claim. The other parts are, do you have coverage for this? What caused the loss? There are three or four major issues. The value of your loss is only one piece of it, but that's the piece where the policy says, and this is in almost every property or homeowner's policy you're going to find, that if there is a dispute about the value of the loss, then either side can demand an appraisal to determine what that value is. And it's basically, most of you have probably heard about arbitration. It's basically a form of arbitration, because it doesn't go to court. It's an alternative way of resolving that particular dispute. And an appraisal is a formal proceeding in which three people appointed by the parties, usually who are experts in this area, get together, and there's a hearing at which both sides get to produce their evidence on what the value is. Typically, each side will appoint one appraiser, and then the two appraisers, one for each party, select a third, who's usually called an umpire. So that if the two party appraisers are unable to agree on an amount, and they usually aren't, then the umpire will break the tie, and then you'll have a resolution of the value of your loss. Now, appraisals, honestly, I find are rarely in the interest of the policyholder. There are a number of problems with them. One is you're paying the bills of 3 people to help decide what your loss is, because those appraisers don't come for free. The insurance company doesn't pay. The insurance company only pays for its appraiser and half the cost of the umpire. You got to pay for your appraiser, and they usually charge by the hour, and they ain't cheap. And you've got to pay for half the hourly rate of the umpire as well, right? So unless you've got a lot of money, unless you've got a very, very substantial amount of money at stake, and you've got some extra cash sitting around to pay for these appraisers to decide the amount of your loss, it's rarely an advantageous way for the policyholder to resolve this dispute. The problem, though, is that most policies make them mandatory upon the demand of one side or the other, right? So if you've got a dispute about the amount and you can't agree, you can go to court, but if the insurance company says, wait a second, we want an appraisal first, you're generally stuck with that. And then you'll have the appraisal, and the appraisal will determine the value of your loss. You'll still have other issues, probably, whether it's covered, what caused the loss, whether you have enough, whether your limits are adequate, all those other issues that I think have probably been covered in past programs. But if the insurance company demands that appraisal, then you're going to be stuck going through that process. And when it's, and again, unless there's a huge amount of money at stake, it's tough to justify those hourly rates for those appraisers to take you through that process. Now, it's not automatic that the carrier will always demand an appraisal. Typically, they only do when the value of the loss is the big issue. If there's no dispute about coverage, if the other issues aren't really in play, then they will often demand an appraisal. But if there's other issues in play, then often they won't. Really what this gets to is when it comes to your options, we rarely recommend that you demand an appraisal because they really don't typically work very well for policyholders. The thing to know about appraisals, though, is they're like arbitration. They are a binding determination of the value of your loss. No appeal, no going to court. You're done on that issue, and so it really is. It's an important procedure that you need to be aware of, and that you need to think long and hard about before you invoke it. So that's a little bit about appraisals. Karen's talked a fair amount about mediations. I think you all understand by now pretty much how mediations work. There is a particular procedure that is provided by the California Insurance Code for certain types of homeowners and earthquake coverage or earthquake policy claims. And the procedure has been around for about 10 years. And it's available under certain types of circumstances. It's available to you if the total amount of your claim is at least $7,500. And there's at least $2,500 in dispute. So there's $2,500 at least separating you and the insurance company from a resolution. Your property also has to be in a county that the governor has designated as a disaster area. And it is limited to residential property. In other words, if you have a business and you have commercial coverage for your business, that policy, that property isn't eligible for this particular program. Doesn't mean you can't mediate the dispute, it's just not eligible for the DOI program. Now, there are also some limits on what you can mediate in this Department of Insurance program. You can mediate things like the scope of your loss, how much of your property was damaged, what that damage was, what it costs. You can mediate whether you have upgrades that are mandated by local building codes that you're actually required to make when you rebuild. one of the complicated issues that often come up in losses like this is you've got building codes that have changed over time and in great likelihood very substantially from the time that you built your home. And your policy usually provides limited but not full coverage for the cost of complying with those new building codes. And the policies usually have a provision that says we only cover building code upgrades that are required, that are mandated by law. Now here's the tricky part that comes into play there. Does mandated mean that's what the law says? That's what the building code says? Or does mandated mean that's what the law says and the building department or the planning department is actually making you do it as a condition of getting your building permit and getting your plans approved? Many carriers take the position that these are only mandated upgrades and only covered if the building department or the planning department is actually making you do it. You may decide, well, gee, this is the new building code. I want my home to be rebuilt according to building codes, among other reasons, because you may want to sell it someday and you don't want to have building code issues when you go to sell your house. But that can be an issue with this code upgrade coverage. So that's an issue that can be mediated in this DOI process. Yeah.
Such an important point, and I didn't totally get the concept. Could you
Sure.
try it just one more time?
Yeah, of course. Your policy has limited coverage. Let me back up a little bit. Your policy provides coverage for the cost of rebuilding your home. And generally you have a limit of coverage for that was set back when you bought your policy originally. Hopefully you have updated it periodically, consistent with inflation and the rising costs of reconstruction and so on. Your policy has a variety of formulas about what happens if, when you have a loss, your policy limit isn't adequate to cover the full cost of reconstruction. And you can, depending on how much you want to pay, you can buy more and more favorable formulations of that, all the way up to what they call guaranteed replacement cost coverage, which isn't available everywhere, and it's pretty expensive to buy, but it is out there. Now, if you have something less than guaranteed replacement cost coverage, then one of the pieces of your reconstruction cost that probably isn't going to be fully covered is the cost of not just rebuilding your home back to the way it was, but complying with any new building code requirements that have come up in the meantime. For example, there may be a building code now that requires you to have sprinklers in your home. That's a great example. It wasn't required 10, 20, 30 years ago. It's required now. That's going to add a big chunk to the cost of reconstruction. Your policy generally says we will pay, in addition to that limit of coverage, we will pay up to X dollars for building code upgrades that are mandated by law. Right? But when push comes to shove and you've got that claim, some carriers take the position that those upgrades aren't actually required unless, when you go down to get your plans approved and go to get your building permit, the folks at those offices say, you got to have this. So, not all building code provisions are enforced, is what I'm saying. Right? A good example is, this doesn't come up for you it doesn't come up much in the residential context, but a lot of times, there are requirements to comply with the Americans with Disabilities Act, more in public buildings. And a lot of times, even though those requirements are on the books, the cities don't always require them. And so you can get into a fight with your carrier about whether, even though you want to make those changes, they may or may not pay you for them. I'm a little off track, but that's, I wanted to answer your question, and that's just by way of an example, one thing that you can mediate in this DOI process, and maybe a very good issue to try to mediate in a DOI mediation. Some of the other issues that come up. Do you have damage to your home or your property that pre-existed the loss? Usually the carriers are going to say, well, you know, and this doesn't happen obviously in a total burn down situation, but in a partial loss, you may have problems with your home that pre-existed the fire, and they're going to take the position that they don't pay for that. Sometimes that's something that needs to be sorted out in a claim process. There are some other issues that are appropriate for DOI mediation too. Let me cover quickly the ones that aren't, because this is important. The DOI mediation, they will not, coverage issues. Does the policy cover this or that? How do you interpret the language of the policy to apply to this or that? Those issues are not eligible for DOI mediation. And the thought is that those are really issues that have to be addressed by the courts, and the DOI does not have jurisdiction itself to tell an insurance company when a claim is covered and when it's not. That's up to the courts to decide. So that's not an issue that's suitable for DOI mediation. So if that's the big problem in your claim, DOI mediation really isn't suitable. Let me move on. There's a very simple process to invoke DOI mediation. All you do is you go online and you file what's called a request for assistance with the DOI. It's a pretty simple form to fill out. You can fill it out online or print it out, write it out, mail it in, either way, whatever works for you. That will trigger then this process, because the DOI will get your request. It's basically your complaint about how the carrier isn't properly handling your claim. They'll review it. If it raises issues that are suitable for DOI mediation, they will then write to the insurance company and say, you've got 28 days to resolve this. If you don't, we're sending this to mediation. And generally, they have to do it. The mediators are DOI appointed mediators, and generally they're pretty good. You can generally depend on them being neutral, certainly not favorable to the carriers, and you know, they generally do a good job. And I should make a point there about mediators and mediation generally. When you're choosing a mediator, as Karen suggested, you certainly don't want anybody who's you know, in the pocket of the carrier or is compensated for them or something like that. But remember, with mediations, there's nobody making a decision. You're not going to walk out of there with somebody having ruled in your favor or ruled against you. So a good mediator is really somebody who's going to be able to change both sides' minds and bring them together. Most of the time you spend in a mediation, you spend in those private sessions particularly, you spend listening to the mediator tell you about the weaknesses in your position. And then they're going to go to the insurance company in their private session and they're going to do the same thing. Why? Because that's how you bring parties together on an amount that both can live with. There's an old lawyer's expression that, you know, a good settlement is an agreement that neither side is happy with, but which they're prepared to live with, and that's the result of a successful mediation. The mediation process is pretty similar to the one that Karen described generally. There's not a lot that I can add there. But hopefully the outcome is that you have a voluntary resolution of your claim. One of the nice things about DOI mediations is the insurance company cannot have a lawyer there unless you do. And you don't have to have one. So if you'd prefer not to be burdened with having lawyers involved in the process, then you just tell the mediator at your pre-mediation conference that you are not going to be represented by counsel. The mediator will ask you. And if you're not represented, then the insurance company cannot bring its own lawyer. Now, I'll tell you that's of limited help, because as Karen told you, these folks, it's what they do every day. They negotiate, they dispute coverage, they argue about the amount of your loss, they negotiate, it's what they do, and you're going to be at something of a disadvantage there without a lawyer or without somebody experienced representing you. But particularly in smaller cases, and particularly in cases where the dispute is mostly about the cost, those are the areas where I think it's probably, you're at least where you don't really need a lawyer, because most of it is going to be about convincing the mediator, that you're able to support the costs that you're claiming, and that you've got a reliable repair estimate, that you've got receipts or some other proof of, ownership and value of the stuff you lost. If you can roll into a mediation with that kind of factual support, then the mediator is going to go to the insurance company and say, look, this person has a supported claim. This is something you really need to take seriously and treat this person fairly. And so in those types of disputes, I think often you may be okay without a lawyer. A lot of these other areas, I think it's tough, because you're up against somebody who's if not a lawyer, has a lot of those same skills and a lot of that experience. So let me talk a little bit about kind of what happens if mediation doesn't work, and if it's not a dispute subject suitable for an appraisal. Your option, of course, is going to court. And you're pretty much going to have to go to court if you can't resolve things like coverage disputes, interpreting what the policy language means, resolving what the cause of your loss was, because as you know by now, there are certain causes of your loss that are covered and some that are excluded, and often that's a big area for disputes with carriers. Those disputes, if they can't get resolved, you don't really have much of, other than non-DOI mediation. You're really kind of stuck with going to court if you're not satisfied with what the carrier is offering you. Let me talk then a little bit about the litigation process. And I think I want to spend most of my remaining time. How much time do I have?
You've got technically 3 minutes. How about we'll make it 5?
Okay, that's good. I want to spend most of the remaining time on how to hire a lawyer and what to look for, because the litigation process, most of you have some idea about it. I'll run through it briefly, but I want to leave you with some tips on hiring a lawyer, because I think that's the most important advice I can really give you here for those of you unfortunate enough to have to go through the litigation process. The first thing to know is that there are a number of different ways to pay a lawyer. Most of us are familiar with a contingent fee. That means you don't pay unless you get a recovery, and then the lawyer takes a percentage of what you recover. Now, contingent fees are, they're great in the sense that they are often the only way that most people can afford to pay a lawyer. Even the cheapest lawyers I know are still $200 and $250 an hour. So, often it's the only way you can afford to pay a lawyer. But just know that, we all hear that, contingent fee lawyer, you're going to pay 33%, you're going to pay 40%. And that is kind of the standard going rate for hiring a lawyer to represent you in a lawsuit. Well, if you have a personal injury claim where you've got, you could potentially recover some significant money for emotional distress beyond what you have to pay for your medical bills, then paying some lawyer 30 or 40% of that, while it's not great, at least is doable. You folks are in a very different, when you have a property insurance claim, you're in a very different situation, because what are you going to get at the end of the litigation? Unless you prove that the carrier acted in bad faith, which is going to require going to trial. They never pay to settle bad faith cases without going to trial. So unless you go that far down the road, what you're going to get in the ideal world is enough to rebuild your house. Well, what do you do when you got to pay 30 or 40% of that to your lawyer? It's tough. Now, there aren't a lot of great options, but what I want to leave you with is the idea that all lawyer fees are negotiable. So, you know, when you're shopping around, when you're interviewing lawyers, when you're getting referrals, don't automatically assume that, you know, you need to pay 33 or 40% of your recovery. These fees are negotiable. And it may depend on what your objective is. For example, you know, if what you want is a lawyer to represent you at a mediation, there are lawyers who will represent you for, you know, maybe 15 or 20% of the recovery. They may also be willing to do it for a fixed fee. You know, if you want a lawyer to ghostwrite your letters and just kind of give you some ongoing advice about how to handle your claim, a lawyer is usually going to charge you by the hour for that, but you might be able to get them to agree to do it for a fixed fee. It'll be more than you want to pay, but it'll at least be a knowable amount that you won't have to worry about being surprised by at the end of the day. A couple of other things about hiring lawyers. It's important that you hire an insurance lawyer who represents policyholders, yes, but it's also very important that you hire an insurance lawyer who knows this area of the law. Property losses are very persnickety. There's a lot to know about the coverages. There's a lot to know about about how to value claims. There's a lot to know about how carriers handle them. And, you know, you really want somebody who has experience with those types of claims. So that's a question you definitely need to ask at any stage of the process where you're hiring a lawyer to represent you in something like this. Hire somebody that you're comfortable with, because you're going to live with this person for a while, and you're going to spend more time with them than you want to. And you want to obviously you want to trust them, but you also want to feel comfortable with them. You want to feel comfortable that you can ask questions and that you're not going to be demeaned when you ask those questions, that you're going to be treated with respect. You also want to get real clear with the lawyer about how the lawyer is going to communicate with you. One of the biggest complaints about lawyers is that you hire them and then you never hear from them again until it's time to settle your case. So, you know, be a good consumer. Deal with that issue up front. How are you going to communicate with me? How often? Here's the information I'd like you to provide me. Put it in the fee agreement. The lawyer has to have a written fee agreement with you. Put that in the fee agreement. Lay out your expectations. Be a good consumer when you're hiring a lawyer, not just, you know, when you're buying insurance or something else. So those are some things I wanted to, you know, the main things I wanted to cover about hiring a lawyer. The litigation process, the thing to know about it is that it is not quick. It usually takes a long time. The typical amount of time between the filing of a complaint in court and the time that it goes to trial is usually about 2 to 2.5 years. All right, and it can be much longer. You may get to a resolution sooner than that because courts are increasingly pushing litigation into mediation. And sometimes you can get an early mediation, but it's rare now that insurance companies will mediate early in the case. Because if it's in litigation, that what they are going to want to do is they're going to want to take all the discovery. They're going to want to take your deposition and get all the documents and get all the information they can to try to set up whatever defenses they can to your claim. And then they'll come and talk about mediation after, you know, 6 months or a year has gone by and you've lived with your loss for that additional period of time. So, you know, there are times when you're not going to have any choice and litigation is really going to be your option, but go into it, you know, with your eyes open, that it's less than a perfect process, and it's going to take some time to get you to get you a result. I think I'll leave it at that, and then we have some time for questions. I hope this has been helpful.
It was fantastic. Thank you so much. I wanted to say thank you to our videographer tonight, Kimberly Carr. She's going to be shutting down now as we go into our Q&A, but just want to acknowledge her for doing that. So thank you so much. So thank you, Kimberly. So it was very kind of her. So.